Frame of suit order to CPC. Inclusion of a whole claim. Rule 12. Every suit must include the whole of the plaintiff's claim in respect of the cause of action. And as far as practicable, all matters in dispute between the parties be disposed of finally. The intention of legislature underlying the provision appears to be that as far as possible, all matters in dispute between the parties relating to the same cause of action should be disposed of in the same suit so as to prevent further litigation. As far as practicable. The word as far as practicable indicate that in each case the court will have to see whether it was practicable for the plaintiff to frame his suit as to include a cause of action which he had omitted or intentionally relinquished. Thus, this provision is more in the nature of a general policy statement than a mandatory requirement. Splitting of claim. Order 2, Rule 2 lays down that every suit must include the whole of the claim to which the plaintiff is entitled to represent in respect of the cause of action, and where the plaintiff omits to sue for it or intentionally relinquishes any portion of his claim, he shall not afterwards be allowed to sue in respect of the portion so omitted or relinquished. Order 2, Rule 2 reads as under 2.1. Every suit shall include the whole of the claim which the plaintiff is entitled to in respect of the cause of action, but the plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of any court. Where a plaintiff omits to sue in respect of or relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. A person entitled to more than one relief in respect of the same cause of action may sue for all or any of such reliefs, but if he omits, except with the leave of the court, to sue for all such reliefs, he shall not afterwards sue for any such relief so omitted. The provision of Order 2, Rule 2 is based on the cardinal principle of law that a defendant should not be vexed twice for the same cause. The principle contained in this provision is designed to counteract two evils, namely 1. Splitting of the claim and 2. Splitting up of remedies. In Navakumar versus Radhesham, the Privy Council stated, the rule in question is intended to deal with the vice of splitting a cause of action. It provides that a suit, must include the whole of any claim which the plaintiff is entitled to make in respect of the cause of action on which he sues, and that if he omits, except with the leave of the court, to sue for any relief to which his cause of action would entitle him to, he cannot claim it in a subsequent suit. The object of this salutary right is doubtless to prevent multiplicity of suits. The Supreme Court has also stated that Order 2, Rule 2 is based on the cardinal principle that defendant should not be vexed twice for the same cause. Order 2, Rule 2 and res judicata interpretation. The proviso of Order 2, Rule 2 are penal in nature and divestive in effect. They should therefore be construed strictly. A plea of Order 2, Rule 2 is highly technical and deprives the party to a legitimate right otherwise available to him. Hence, it should not be lightly upheld. Such plea should be raised at the earliest opportunity. Illustrations. A lets a house to be at a yearly rent of 1200. The rent for the whole year of 1905, 1906, 1907 is due and unpaid. A sues B in 1908 only for the rent dues of 1906. A shall not afterwards sue B for the rent due for 1905 or 1907. Next, A advances loan of 2200 to B. To bring the suit within the jurisdiction of a court X, A sues B for 2000 only. A cannot afterwards sue for Rs 200. A sues B for Rs 200. As against this claim, B claims set off for Rs 200 being part of the 1200 due to B by A, but omits to counterclaim the balance of 1000. B cannot afterwards sue A for 1000. A sues B for possession of alleging that B is a tenant in arrears. The suit is dismissed on the ground that B is a mortgagee in possession. The subsequent suit by A against B for redemption is not barred. A sues B for rent. The suit is dismissed on finding that A was not a landlord, but A and B were co-tenants, tenants in common. Subsequent suit by A against B for partition of property is not barred. Condition. To make a rule applicable, the following three conditions must be satisfied, namely, second suit must be in respect of the same cause of action as that on which the previous suit was based. In respect of that cause of action, the plaintiff was entitled to more than one relief, and being thus entitled to more than one relief, the plaintiff without leave of the court omitted to sue for relief for which the second suit has been filed. In other words, before the bar of Order 2, Rule 2 is invoked, the following three questions should be asked. Whether the cause of action in respect to the previous suit and the subsequent suit is identical, whether the relief claimed in the subsequent suit could have been given in the previous suit on the basis of the pleadings made in the plaint, whether the plaintiff omitted to sue for a particular relief on the cause of action which has been disclosed in the previous suit. Same cause of action. In order to apply to the provisions of Order 2, Rule 2 of the second split, bar the second suit, it must be proved that the second suit must have been based on the same cause of action on which the previous suit was based. Unless this condition is fulfilled, there could be no bar to the subsequent suit unless there is identity between the cause of action on which the earlier suit was filed and that on which the claim in the later suit is based. There would be no scope for the application of the bar of Order 2, Rule 2. The cause of action should not merely be similar, but it must be the same. As Mullah states, the rule does not require that when several causes of action arise from one transaction, the plaintiff should sue for all of them in one suit. What the rule lays down is that there is one entire cause of action and the plaintiff cannot split the cause of action into parts so as to bring the separate suits in respect of those parts. What the rule lays down is that there is one entire cause of action. The plaintiff cannot split the cause of action into parts so as to bring the separate suits in respect of those parts. When the subsequent suit is based on a cause of action different from that in the first suit, the subsequent suit is not barred. The rough test, although not a conclusive one, as to whether the cause of action in a subsequent suit is the same as that of the former suit, is to see whether the same evidence will sustain both the suits. What the rule requires is the unity of all claims based on the same cause of action in one suit. It does not contemplate unity of distinct and separate causes of action. If the subsequent suit is based on a different cause of action, the rule will not operate. The rule is directed to securing the exhaustion of the relief in respect of a cause of action and not to the inclusion in one and the same action of different causes of action, even though they arise from the same transaction. One of the tests is whether the claim in a subsequent suit is in fact founded upon a cause of action distinct from that which was the foundation of the former suit. If the answer is in the affirmative, the bar does not apply. Thus, where the rent of several years, 8 days తర్వాత వస్తున్నాడు, ఈ 8 రోజుల తర్వాత వస్తున్నాడు, నువ్వు ఆ వాచి తీసుకెళ్ళి వేరే పట్టుకొచ్చాం కదా నల్లది. లేదు ఇవాళ కాదు, 8 రోజులు పడుతున్నాడు. Where the rent of several years is in arrears and the plaintiff states claims, నా నల్లది అది తీసుకెళ్ళి అందుకే పట్టుకొచ్చాది ఇంకోటి, అది పెట్టుకెళ్ళు. వద్దండి, only 1 year he cannot subsequently sue for the rent of other years. Similarly, a suit for specific performance of a contract bars a subsequent suit for damages for failure to perform the said contract. But the dismissal of a suit for specific performance of a contract to transfer land is no bar to a suit for return of the consideration money. So also a suit for reject a defendant on the basis of a lease is no bar to a suit based on title. The dismissal of a suit for enhancement of rent is no bar to a suit for recovery of the rent originally fixed. Like res judicata, a plea of bar order 2, rule 2 must be established by the defendant by placing it before the court the plaint of the previous suit and the other evidence for proving the identity of cause of action in both the cases. The court cannot take cognizance of such a plea suo moto. One of several reliefs. The rule applies only where the plaintiff is entitled to more than one relief in respect of the same cause of action, and he omits to sue for all such reliefs. Thus, where one plaintiff files a suit for damages for breach of contract and omits to claim a portion of the damages for which he is entitled, a subsequent suit for such portion is barred. Similarly, a suit by a co-partner challenging the mortgage of certain co-partnership properties is a bar to a subsequent suit in respect of other properties included in the same mortgage transaction. Such relinquishment of claim need not be expressed. It may be implied in the conduct of the plaintiff. This rule, however, does not apply when the right to relief in respect of which a subsequent suit is brought did not exist at the time of the previous suit, but in the earlier suit the petitioner could not have claimed the relief which he sought in the subsequent suit. As stated by the Privy Council, if a particular cause of action enables a person to ask for a larger and wider relief than that to which he limits himself, he is precluded from claiming the balance by instituting independent proceedings. The crux of the matter is the presence or lack of awareness at the time of the right at the time of the first suit. Leave of the court. The rule applies only when the leave of the court is not obtained. Therefore, if the omission has been with the permission of the court, the subsequent suit for the same relief in respect to the same cause of action is not barred. Such leave need not be expressed. It may be inferred from the circumstances of the case. It can be obtained at any stage. The power to grant leave is discretionary. Normally, the exercise of such discretion will not be interfered with by a superior court. Test. Test. The test for finding out whether a subsequent suit be barred because of the previous suit is whether the claim in the second suit is in fact founded on a cause of action which was the foundation of the former suit. If the answer is in the affirmative, the bar of the order 2, rule 2 would apply, but if it is in the negative, it would not be attracted. Principles. In Muhammad Khalil versus Mehboob Ali, after considering several cases on the point, the Privy Council laid down the following principles governing bar to the subsequent suit under this rule. The correct test in cases falling under Rule 2, Order 2, Rule 2 is whether the claim in the new suit is in fact founded upon a cause of action distinct from that which was the foundation of the former suit. The cause of action means every fact which will be necessary for the plaintiff to prove if traversed in order to support his right of the judgment. If the evidence to support the two claims is different, then the cause of action are also different. The cause of action in the two suits may be considered to be the same if in substance they are identical. The cause of action has no relation whatever to the defense that may be set up by the defendant, nor does it depend upon the character of the relief prayed for by the plaintiff. It refers to the media upon which the plaintiff asks the court to arrive at a conclusion in his favor. Applicability to other proceedings. The provision of Order 2, Rule 2 apply only to suits and not to appeals, execution proceedings, arbitration proceedings, or a petition under Article 226 of the Constitution of India. Joinder of claims. Rule 45. Rule 4 and 5. Rule 4 and 5 provide for joinder of claims. Rule 4 lays down that in a suit for a recovery of immovable property, a plaintiff is not entitled, without the leave of the court, to join any claim except the claim for mesne profit or arrears of rent in respect of the property claimed or any part thereof, claim for damages for breach of contract under which the property or any part thereof is held, claim in which the relief sought is based on the same cause of action. Rule 5 deals with the suits by or against three classes of persons: executors, administrators, and heirs. It provides that no claim by or against the aforesaid persons in their representative capacity shall be joined with the claims by or against them personally in the same suit, except where the personal claims arise from the reference to the estate he represents, nor where he was entitled to be or liable for those claims jointly with the deceased whom he represents. The primary object of these provisions is to prevent a representative from intermingling the assets of his testator with his own estates. Joinder of causes of action. Rule 5 and 3 and 6. Rule 3 deals with the joinder of causes of action. This rule enables the joinder of several causes of action in one suit in certain circumstances subject to the provisions of the code. Rule 4 and 5 and Order 2. Rule 1 and 3 of Order 1. It contemplates the following four types of situations: one plaintiff, one defendant, and several causes of action. Where there is only one plaintiff and one defendant, the plaintiff is at liberty to unite the same suit several causes of action. But if it appears to the court that the joinder of causes of action may embarrass or delay the trial or is otherwise inconvenient, the court may order separate trials. Joinder of plaintiffs and causes of action. When there are two or more plaintiffs and several causes of action, the plaintiff may unite such causes of action in one suit against the same defendant if they all are jointly interested. But this provision must be read with Order 1, Rule 1. Thus, where there are two or more plaintiffs and two or more causes of action, they may be joined in one suit only if the following two conditions are fulfilled. The causes of action must arise from the same act or transaction, and the common question of law or fact must have been involved. Therefore, where the plaintiffs are not jointly interested in several causes of action which have been joined in one suit and the right to relief does not arise from the same act or transaction, or where the common questions of law or fact are not involved, the suit will be bad for misjoinder of plaintiffs and causes of action. Joinder of defendants and causes of action. Where there is one plaintiff and two or more defendants and several causes of action, the plaintiff may unite in the same suit several causes of action against those defendants, if the defendants are jointly interested in the cause of action. But this provision also must be read subject to Order 1, Rule 5, and therefore two or more defendants can be joined in one suit provided the following two conditions are fulfilled. The relief claimed must have been based on the same act or transaction, and the common question of law or the fact must have been involved, where in one suit two or more defendants have been joined against whom the cause of action are separate, and therefore they are not jointly liable to the plaintiff in respect of those causes of action, and the right of relief claimed is not based on the same act or transaction, or where common questions of fact of law are not involved, the suit will be bad for misjoinder of defendants and cause of action, technically called as multifariousness. Joinder of plaintiffs, defendants and causes of action. Where there are two or more plaintiffs, one or more defendants and several causes of action, the plaintiffs may unite the causes of action against the defendants in the same suit only when all the plaintiffs are jointly interested in the cause of action and the defendants are also jointly interested in the cause of action. If the plaintiffs are not jointly interested in the same cause of action, the suit will be bad for misjoinder of plaintiffs and causes of action. On the other hand, if the defendants are not jointly interested in the causes of action, the suit will be bad for multifariousness. And if neither the plaintiffs nor the defendants are jointly interested in the causes of action, the suit will be bad for double misjoinder, that is, misjoinder of plaintiffs and causes of action, and misjoinder of defendants and causes of action. Objections as to misjoinder of causes of action. Rule 7. All objections on the ground of misjoinder of causes of action must be taken at the earliest opportunity, otherwise they will be deemed to have been waived. Similarly, no decree or order under section 47 of the court can be reversed or substantially varied in appeal inter alia on account of any misjoinder or non-joinder of causes of action, not affecting the merits of the case or jurisdiction of the court. Institution of suit. Order 4. General. Section 26, Order 4. For institution of suit, Order 1 deals with the parties to a suit. It also contains provisions for addition, deletion and substitution of parties, joinder, non-joinder and misjoinder of parties, and the objection as to non-joinder or misjoinder of parties. And misjoinder. Order 2 lays down rules relating to the frame of suit, splitting and joinder of claims, joinder of causes of action, and objections as to the misjoinder. Plain meaning. The expression plaint has not been defined in the code, but it means a private memorial tendered to a court to which a person sets forth his cause of action, the exhibition of action in writing. Presentation of plaint. Section 26, Order 4, Rule 1. Every suit must be instituted by the presentation of a plaint in duplicate or in such other manner as may be prescribed by the code, by the plaintiff himself or by his advocate, or by his recognized agent or by the person duly authorized by him. Therefore, generally a proceeding which does not commence with a plaint is not a suit. Time and place of presentation. A plaint must be presented in the court or such officer as it appoints in that behalf. Generally, the presentation of a plaint must be on a working day or during the office hours. However, there is no rule that such presentation must be made either at a particular place or a particular time. A judge, therefore, may accept a plaint at his residence or at another place after office hours, though he is not bound to accept it. But if not too inconvenient, the judge must accept the plaint. Which is the test? Last day of limitation. Thereafter, the particulars of a suit will be entered by the court in a book kept for the said purpose, called the Register of Civil Suits. After the presentation, the plaint will be scrutinized by the stamp reporter. If there are defects, the plaintiff or his advocate will remove them. Thereafter, the suit will be numbered. Particulars in plaint. Every plaint must contain necessary particulars. Register of suits. Particulars of every suit will be entered in the Register of Civil Suits. Suit by indigent persons. Order 33 of the Code deals with the suits by indigent persons or paupers. Suit against minor. A suit against a minor can be said to have been instituted when a plaint is presented and not when a guardian ad litem is appointed. Suit against a dead person. According to one view, a suit against a person who is dead at the time of institution thereof is a non-est and of no legal effect. According to the other view, however, such a suit is not void ab initio and can be continued against legal representatives of the deceased defendant if they have been brought on record in accordance with law. Thus, if a suit is filed against a dead person by a plaintiff without the knowledge about the death of the defendant and takes prompt action as soon as he comes to know about such death, then he cannot be deprived of his remedy against the legal representatives of the deceased defendant.